Hello and welcome to tutorial key point video number 3. Started off by looking at TMA01, and I've made a separate video on getting higher marks in ETMAs, which I'd encourage you to have a look at, and the table associated with it. The key points to highlight in TMA01, question 1 invited you to describe, but the key word there was explain incorporation. Why incorporation was necessary, how it was done, and why it was done in that particular way. That's what I was looking for. Question 2, again, the emphasis is on explaining and evaluating. And to do that, as I said in the last tutorial key point video, DICE is an excellent tool to use to base your evaluation on. As I say, it doesn't matter whether you agree or disagree with him, it's how you do that evaluation, and that will get the highest marks. Into the tutorial itself, and we're looking forward to those subjects that you'll be doing over the Christmas holidays until the next tutorial. And one subject is judicial review. I've sent to you some links in the last few days, a piece on the Radio 4 PM programme on the government's proposed changes to judicial review, and also some handouts. And what I did in the session was talk through those handouts. Key things to remember is that you've got the different classification, the so-called DIPLOC, illegality, irrationality, and so on. With perhaps a fourth one being the human rights ones added by the Human Rights Act, although one could actually argue that that's just another form of illegality. In your textbooks, you will see that under those main headings, there are a number of things. I'll describe them as pigeonholes. And what you as a lawyer would be doing is that somebody would be complaining about a decision. They would come to you and say, how can we challenge this decision? The first thing, of course, that you tell them is that you can't challenge the decision on the merits of the decision. That's not what judicial review is about. It's about the way the decision is taken. And under those headings of irrationality, illegality, procedural impropriety, and human rights, there are a number of subheadings, and these really are pigeonholes, and you would select the appropriate pigeonhole for the facts that you're doing. And if you think of them as pigeonholes, make sure that you know what each of those pigeonholes are so that you can apply it to any kind of problem question. You've got the flow diagram I sent you. First issue is the body susceptible to judicial review? So is it a public body itself, or is it carrying out public law powers? Secondly, does the person who wishes to bring the judicial review have standing? Thirdly, what are the impacts of time limits? The normal time limits and any time limits that the statute may have put in, which will of course be shorter. Ouster clauses, quite important. Attempts by governments have been defeated by the anisminic case, so make sure that you've had a look at that case. But ones that are more successful in keeping the courts out. Then, of course, the grounds of challenge, those important ones, the 4 main grounds and their pigeonholes underneath them. And don't forget remedies. What we did in the session was to do some judicial review exercises, and again, have a look at your manual and make sure that you're not just looking at this as a theoretical subject, but that you're looking at it as a solution to specific problems. And I'd encourage you, again, read some judicial review reports, particularly that the Supreme Court has considered. Looking further ahead into the future, you'll be starting the central principles of criminal law. So we'll be asking questions such as, what is a crime? What role should criminal law play in regulating society? Increasingly, we're finding people arguing that, here is a problem, how do we solve it? We criminalize the behavior. Either if you do something that we'd like to discourage, we'll make it a criminal offence, or not doing something can be criminalised. So is this an appropriate way to move ahead? And as we are in a general election year, I'm sure we're going to hear thrown by the opposition. Doesn't matter which party you're talking about, this comes up every general election. The party in government is accused of creating lots and lots of new criminal offences. Well, that may actually be a bit bogus, but there is this increasing turn to using the criminal law to solve what may be just social problems. You can consider that. Look at the classification of offences. Why is it being classified in this way? Is this an appropriate way of classifying? What are the advantages of such a classification? Burden of proof. That's important to look at. Well, you know the general principles that in criminal law the burden of proof is on the prosecution and it is beyond a reasonable doubt. But what are the sort of qualifications for that? Under what circumstances will things change? And you'll be looking at actus reus and mens rea in much more detail than in W200, which is what you've done previously. So don't just skip over that. There's greater subtlety in some of the issues. We finished off by looking at the TMAs coming up on the 7th of January, ETMA 02. You'll be looking at Aiden's claim, so do have a look at the convention rights, identify and explain and apply. Again, compare that with the requirements for the marking bands and you'll see how important they are. So ask yourself, what rights are engaged? When you're balancing qualified rights, when can interference by the state be justified, and apply it to the problem? Look at Aiden's rights under English law. So you're looking at how the Human Rights Act turns the rights in the European Convention into something that Aiden can use in the English court. How will he use those rights? And then a conclusion. On the second part, you're looking at the criminal liability of the Sunday Tribune. So you're going to have to look at the contempt of court, the elements of the offence, the defences, again, a reasoned conclusion. Question 2, key part of the question, critically evaluate and address the issues. Firstly, how do these rights come into play in a dispute between two private persons? ECHR, when it was first thought of, you were thinking about the rights of the individual against their state. This is actually applying it to individuals, although those individuals may be legal individuals. When does the apparent conflict arise? How do the courts approach that apparent conflict, and a conclusion? And this is one, unlike some of the constitutional law issues you've looked at, where cases are important. So make sure that you've had a good look, and this can involve looking at the case itself and looking at the judge's reasoning in these cases. The Campbell case, the von Hanover cases, the Murray, the Mosley and News Group, and the LNS versus, sorry, some Americanism there, the LNS and Persons Unknown. So that's TMA 02. TMA 03, long way ahead, 25th of February, but keep in mind as you read about strict liability, the examples of offences that involve it, and cases on strict liability. Practical, use cases which give guidance, and the justification for strict liability. Critically evaluate the arguments for and against strict liability, the claims and the counterclaims. Well, with that I'll finish. I look forward to seeing you at the next tutorial and receiving TMA 02. Thank you, and have a good Christmas.